No one hit anyone.
Okay.
No one is hurt.
Okay. I just bring it down. Okay. Well,
Scaring me because she literally went upstairs to grab him. She just like threw him to the floor. Like,
She threw your son? Okay.
grabbed him by both arms, picked him up off the ground, and then threw him at that cupboard in the hallway upstairs. They said that he got off of his feet and hit his back and then fell to the ground where your husband caught him. That's what both of them are telling me.
On the afternoon of 28th September 2025, officers in Ohio responded to a residential domestic disturbance call.
I hear somebody in the garage.
There we go. Yeah, you can see stuff all over.
Hello? Hello?
How's it going? Can you step outside with us for a second?
I have an undershirt on.
That's okay. Can you just step outside with us?
Can I just go put an undershirt on, please?
No, can we come in? We're going to come in with you if
Just
you're
come
going to go.
sit down. We don't mind. Believe me, we've seen people in way worse.
Yeah.
Go ahead and step
But I'm
out
on
for us.
camera. Hello. Right?
Yeah, well, your husband's not here. I can come inside and talk to you, okay?
Can you just let me give me
I can't let you be alone. We got called
Why?
because we got called to an active domestic, so this is why we're here.
Come in, sir. Thank you. Can you just take me off camera then so I can go put an
I
undershirt on?
can't. So what's going on today?
Nothing's going on.
Okay, so we see a bunch of stuff outside out front. So how did that all get out there? Like this phones, stuff thrown all over the driveway in the front yard. What's going on with that?
It's music binders.
Okay. Well, there was a phone in the driveway.
That's my phone.
Okay, so what caused all that?
My phone wasn't thrown anywhere
Well, why is it in the driveway then?
because I put it down there.
Okay, well, what's all with all the other stuff in the driveway?
I told my husband to take it and he wouldn't take it and he wouldn't leave. So
Okay.
I threw it out because he's going to need it today.
Okay.
And that's all there is
Are
to
you
it.
trying to kick him out?
I asked him to leave.
Okay, so kind of just back this up a little bit. What started all of this today? Because like I said, we got called to an active domestic.
Okay?
Said someone was throwing stuff all over the house and being really violent. So that's why we're here, okay? So kind of start me from the beginning about what happened and we'll go from there.
About 5 minutes ago, I asked him to leave because he was running late to take my son to swim again.
Okay, so
And I said, you're going to need your stuff.
does
and
he
wouldn't
does he
leave on
live
time.
here?
Yes.
Okay.
And he said I told him he needs to take my music with him
Okay.
because my son is acting out again. And I said, you need to leave now because you're going to be late because his swim class starts at exactly 3:30.
Okay.
And he's missed a lot of classes and he's been late a lot.
Okay.
He's had a lot of absences and I don't want him to miss again.
Okay.
And he wouldn't get his stuff in time. So I threw it out and I said, go.
Okay.
I'm not going to be responsible for him missing another class.
Okay. And you said this has been an ongoing issue with just like with you guys, has things been just like tension's been high, or seems like something with him being late seems that's kind of
He's late a lot.
seems like this is a bigger issue than him just being late today.
Yes, he's late a lot.
Kind of your frustration right now, how he's always late.
He doesn't take care of responsibilities, but I wouldn't say me throwing out is a domestic event. I threw out some music binders.
Okay. So he
And I
said.
set my phone down
Okay.
before I was trying to get in the shower.
Okay.
Which is why I don't have an undershirt on.
Did anybody get violent with anyone?
No one hit anyone.
Okay.
No one is hurt.
Okay, I just bring it down. Okay, we're here to help. Okay, I know you don't will probably want us here, but we're here. Okay, so
I'm
we're just
not
trying to figure out.
upset with
Okay, so he did say that you potentially had been violent towards so we
Hudson
are
is not hurt. Hudson
okay.
is not anything.
Well, I'm gonna have to talk to him.
That's fine. You can go do that.
Where is he
He's
at?
very upset because I made him do his homework today, and he
Okay.
didn't want to do his homework.
How old is he?
He's
Okay, no, he wants to do the homework, so it makes sense. Okay.
He doesn't want to do homework. I had
Where's-
to cancel his composition today because he didn't have his homework done. He didn't have
Okay.
his assignments finished, so he was
Okay.
very upset. He
Okay.
was rebelling. He didn't want to do his music, and I said, "Will
Okay.
you take your music out then?"
Okay.
And you get to class on time. You can't
Okay.
be late again.
Okay.
So he's rebelling and acting out because I'm asking him to get his homework
Okay,
done.
where's he at right now?
He's out there.
Outside?
Yeah.
Where was he? I didn't see him when we walked up. Was he in a car or something?
He might have gotten in the car.
Okay.
He's supposed to be at swim. Like, he's late.
Okay, I
That's
gotcha.
what I'm explaining.
Okay.
Yes.
Okay. Which car would he be in?
The red one.
Okay, the red
It's
one.
right out
We'll
front.
go talk to him. Do you have your ID on you by chance, or do you have access to it?
You need my ID?
I do. So we are investigating a domestic incident. So We by law have to take a report, so we have to identify all the parties.
You're taking a police report today? My husband is causing a police report because I put some music outside?
Well, when there's accusations
Oh my
of violence. Well, it does. Like,
Do
ma'am,
I need to call my attorney?
ma'am, we're not. No one's under arrest right now. We're just doing an investigation to determine if there was a domestic incident that happened.
There's no domestic
Well,
incident that
how
happened.
am I supposed to know that? We just got here. I have to talk to you. I have to talk to him, and I have to talk to your son to figure out exactly
He
what
just
happened.
left.
Your husband is right there.
Then my is right there.
Okay, and like I said, we're gonna talk to all the parties.
Well, then can you go talk to him?
We will. That's why I need to get you identified and get your ID.
I missed this swim class again.
I apologize for that, but I have a job to do, and that's what we have to do.
I understand. Yes, I will get
Okay.
you whatever you need to have.
Ohio Revised Code Section 2919.25 defines domestic violence as knowingly causing or attempting to cause physical harm to a family or household member. The statute does not require documented injury. It does not require emergency medical response. It requires that the act occurred or was deliberately attempted. This is a distinction that subjects in domestic investigations frequently misunderstand. The absence of visible harm is not a defense to the charge. It may be relevant to the severity of the offense. It is not relevant to whether the offense occurred. Physical harm under Ohio law includes any injury, illness, or physiological impairment, regardless of its gravity. A push that causes a person to stumble qualifies. A throw that results in a near fall qualifies. The threshold is low by design. Ohio Revised Code Section 2935.032, subsection A, removes officer discretion once probable cause for domestic violence has been established. The operative word is shall. When an officer has reasonable grounds to believe a domestic violence offense occurred and probable cause to identify the offender, the statute commands arrest. There is no discretionary carve-out.
Here. 628. You have Emily attached. I will give this back to you. Okay. Do you mind watching her and we will talk to you?
I need to be watched.
Ma'am, like I was explaining to you, this is a domestic incident. We have to keep both parties separated, and then we'll kind of go from there. Like I said, no one's under arrest. I have to talk to all the parties involved, and then we'll go from there. I understand you're upset, but that's just what we have to do right now, okay?
I just feel like I'm being treated like some kind of a criminal.
Hi, what's going on?
She saw something on like the history of YouTube. Hudson, he's been having problems with, getting on YouTube shirts and things like that during school when he's not supposed to.
Okay.
And me and her, we've been having a little trouble because he's been very disruptive and argumentative with her. It was getting aggressive. It was scaring me because she literally went upstairs to grab him. She just like threw him to the floor. And said,
She
"Get
threw
out!"
your son? Okay.
And it just,
Is he okay? Does he have
He's
any...
okay. He's okay. I mean,
Okay. Do you want him checked
physically,
out?
he's okay.
Okay.
Physically, he's okay.
Okay.
But I mean, like,
So
she's been trying to kick me and him out of the house altogether for a little while now, and for one reason or another, she's just really angry and upset.
Okay. Is there any mental health history or anything like that?
I mean, with her, no.
Okay.
I mean, I have ADHD, but
Okay.
it's
So
handleable. I take medicine for it.
So she got angry because she saw something on
Like
the
YouTube
kids'
history.
Okay.
Yeah.
Your iPad.
It was the song was
Go
called
ahead.
"Devil in Disguise." It's just a song. It's not actually like demonic or anything. It's actually just a story of,
And
But
we
she
can
saw
slow
the
it
word
down
devil
now.
and she blew up. So she's
Okay, so she saw that, and he's the one that searched it.
So he did originally a while ago, but for this morning I did because I was listening to the song.
Okay.
I wanted to see what it was about and everything.
Okay, because you saw that he was listening
Yeah,
to
so
it.
he's
Okay.
listening to it. I'm like, I should find out more about that.
Gotcha.
Listen to the song. It's actually, more of a warning of, not judging books by a cover. And,
Okay.
stuff like
How
that.
old is he?
He is
11. Okay. All right. So she did throw him to the ground, you said. Anything else physical?
So no, not against us. She did throw a bunch of his stuff out on the lawn, and she picked it up, which is
Yeah. Well, some of it.
Most
Yeah.
of it, I guess.
Okay.
Actually, most of it. It was.
Is this your
it was
phone?
strewn. This is not. This is her
Okay.
phone.
Okay.
That's my shoe. This gold book. And
So nothing physical with you, but she did
not with me.
throw him. Is there, obviously we're going to look into this a little more. We're going to, get both sides of the story, whatever she says and stuff.
Of course.
But is there any place that maybe you guys can go today, or she can go?
Well, right now I was going to take him to swim, and then I have piano lessons that I teach afterwards, and I guess I was going to take him with me
Yeah, that's probably the best
to do those
idea.
things.
Okay. Do you have a driver's license on you?
I have a driver's license. Yes, I have a
Okay.
driver's license. You
All right.
need to see that.
Yes, please.
So there's that.
6.7 for a DO. Zero zero. So copy. So here's this back for you. So when he threw, you said is his name? Okay. When she threw him, like how did he do?
So
how
he
did she do?
he was in the room. She was telling him he had to get out. I've had enough of it. I don't want him here anymore. And then he was upstairs and sitting, and she grabbed him, towards the doorway, and through the doorway and stuff like that. I ended up he fell to the ground.
Okay, I'm sorry. I was looking at the. So
No.
she.
I caught him to at least from
What?
It's Washington.
Yeah.
I caught him from the worst of the fall. I mean, he fell down, but at least I
So when she
stopped
grabbed
his-
him, how did she grab him?
So she was starting to walk past her and stuff like that, and she grabbed him and
Like shoulders, like.
just like shoulders and
Yeah.
and
Okay. He didn't hit anything. You were able to catch him. You said.
I was able to catch. He kind of like went through the door and stumbled and fell, and he like turned as he was going down.
Okay.
And I ended up catching his like shoulders and head before it,
Okay.
fell to the floor.
Okay. I'm gonna get him started on a witness statement real quick, and then I'll come to.
Is it Joseph, correct?
Yes,
So I know
yes,
you
sir.
probably explained to that officer. So
Yes, I did.
I'm going to be the main investigating officer for this.
Okay.
So kind of explain to me what transpired, what happened today.
So he was being really resistant to completing like his
Okay,
his
and that's what
work
your
and
wife was
stuff like
saying.
that. And she was he was back talking and,
Okay.
and
Is
all
that
those things.
out of the norm for him, or?
Lately, no.
Okay.
I mean, like he's been doing it a lot lately. Back talking.
Okay.
Just like otherwise being kind of a
Preteen. Okay.
aggressive.
Okay.
I'm not gonna do that.
Okay.
It's snarky and all that. And it's obviously she's not handling it very well. She blows up.
Okay.
She gets I know me and her have been having some issues.
Okay.
And she's been wanting to like get a divorce and quit the whole thing and make her go with me. And
Okay.
she's like ready to like get rid of both of us.
Okay.
But it was fairly civil over the weekend. We were just trying to like get things done.
Okay.
I'm getting him enrolled into a public school so that he can like get out of the house.
Okay.
He's been homeschooled for
Okay.
years.
Okay.
But now it's kind of a problem because he's doing other things other than school during
Okay.
the time he's supposed to be doing school.
Okay.
So anyways, she was trying to do something on YouTube to she was trying to sign him up for a piano competition. One of the things was that you have to put a YouTube video on there, and when she was looking on YouTube, she saw a thing called "Devil in Disguise." Which in her, I had looked up because he had been he had listened to it. He even told me about it, like "Devil in Disguise," and he sang a little bit of it. I was like, oh. So I looked it up to find out what it is. It's actually not bad, even though it has the word devil in it. It's actually more of a warning of not judging books by the cover. And, being wary of,
Yeah.
of people and
Makes
not just
sense.
taking things at face
Okay.
value. But she sees all that and she blew up and she's like, I want him out of the house. I want to, you guys need to never come back. Just take him in and just never come back.
Okay. She
She went upstairs and Hudson was in his room, the school room, and he tried to go past her and she grabbed him and threw him to the ground with his shoulders, and he kind of like did a twist. And
So-
I caught him.
So she went up to the schoolroom
She went up to the
to
school room
get him.
to throw him out of the house. Like,
Okay,
you
so
gotta
she
have
wanted to
have-
throw him out of the house.
out of the house.
Okay.
Yeah, and she even said that along the way. Is this, I want to, I'm gonna throw you out.
Okay.
And,
Yeah.
Do you care if I go talk to him right now?
you can go talk
Yeah.
to him.
Okay.
So
That's fine.
what your wife explained to me is that she said that you were supposed to be taking him to, I believe, swim practice.
I am supposed to be taking this.
And she said that you were running late and that really upset her. She
Okay,
said,
so that's not true.
okay.
All right. There. Okay. So yes, I'm supposed to be going to swim practice. No, it had nothing to do with it being late.
Okay.
She got upset because of what she saw on YouTube and that whole thing. That's what she was yelling about and said, it's
Okay.
got devil in the name and
Okay.
stuff like that.
When
Obviously, we were supposed to be getting ready for swim. He was being resistant to getting ready in the first
Yeah.
place. That's why he was in his room. He
Okay.
wasn't on task.
Okay.
Trying to actually get
Okay.
out the door. He was up there
Okay.
drawing or something. I
Okay.
can't remember what it was, but but anyway, she got upset. She threw him down. I caught him on the way down, and then
So
stood
what do
him
you
up.
mean on the way down? Was it like
So he-
down
he-
the steps, or was
so
it?
it was no, it was through the doorway of
Oh.
the bedroom, and then I reached down and I grabbed
So
him.
he never like hit the ground. You kind of
He
caught
never
him.
hit the ground. I
Do you
grabbed
think-
him before his head
Was
did.
her intent because he wasn't listening to her, or do you think her intent was to hurt him?
She was very, very angry, and she was ready to throw him. She's like, I'm throwing you out. You need to get out of here and never come back. And I'm she said to me, I'm done with you. And she did this, basically said,
Is that her
you never
phone or
come
is that
back.
your phone?
That's her phone.
Okay.
Mandatory arrest legislation was adopted across most U.S. states, following research funded by the National Institute of Justice in the 1980s, specifically the Minneapolis Domestic Violence Experiment, which documented that arrest produced lower recidivism rates than officer mediation or separation. Subsequent studies, including the Spouse Assault Replication Program, across multiple cities produced more nuanced results. But the legislative movement was already in motion. By the early 2000s, the majority of states had enacted some form of mandatory or preferred arrest statute for domestic violence calls. Ohio's version is among the more rigorous. Section 2935.032, subsection B, explicitly provides that an officer's obligation to arrest is not negated by a victim's or complainant's preference not to pursue charges. This provision reflects the legislature's recognition that domestic violence victims are frequently coerced into withdrawing complaints by the very persons who committed the offense against them. Removing victim choice at the arrest stage was a deliberate policy decision, not an oversight. The consequence is that officers arriving at a domestic scene are not mediators. They are not counselors. They are law enforcement officers, executing a statute that has already made the dispositive decision for them once probable cause is established.
She said that was her phone. Okay.
That's her phone. All right, and then
Do you think she intended to hurt him when he did that?
I think she was mad enough to hurt him. Yeah,
Okay.
that's what scared me. Was that? Yeah.
Okay.
That's
So
what made me. That's what made me call.
have you guys been having some difficulties?
We've had some difficulties. Yes.
Okay.
Yeah.
So I was out here last year, I believe.
Yes. Last year.
If I remember correctly, were you suffering from some early onset Alzheimer's? Is that if
Not Alzheimer's.
Okay.
I have ADHD.
Okay.
And then I was also suffering from some.
And I'm not saying that's just from what my memory recalls. I remember that being something that.
It's okay.
Yeah.
I understand. It was a while ago. And,
Yeah.
And you're in the ballpark, I guess.
Yeah.
But ADHD. And
Okay.
then, also depression. So
Okay.
I was having a really hard time.
Okay.
Just coping with life in general.
Yeah.
It's extremely difficult. But
How has her mental health been lately?
lately, she's just getting very angry for
Okay.
just, anything. And
Is it towards you, towards him?
both?
Okay.
Both.
And you said it was pretty good this weekend, and then today just kind of like this.
Well, no, it's not been pretty. It's been like hot and cold.
Okay.
Like sometimes it's like really, really angry. And I mean, just a few days ago, me and spent a couple days in the hotel because she did similar, but without, she basically get out and I never want to see you again.
So what caused you to come back after that? Did she cool down, or?
Well, okay, so she cooled down, yes, and on top of that, our lives are fairly intertwined, and I didn't have this, I don't have family here.
Mm-hmm.
It's not like I could stay with family, and on top of that, it was, we were trying to be like amicable because
Okay.
she's looking to get a divorce, and
Okay.
and I'm like, okay, we'll just work together and
Okay.
until we can do that.
Okay.
So that's kind of where we were. But,
Have you guys started that process, or?
We have not filed for divorce.
Okay.
This was recent. This was only like, we stayed over was a couple days just this last week. When was it? It was Monday and Tuesday. Sunday, and then we stayed in a hotel. Came back Tuesday afternoon, and then
Okay.
I've had to work, and I work three jobs. I work as a trainer in the early mornings, and then I go work at the garden center for
Okay.
afternoon, and then
Okay.
I teach piano in the
Okay.
evening. So I was doing that, and then of course I had to actually call out of work a couple times just this last week on short notice because she's like, I don't want him here anymore.
Okay. Do you think today's outburst with him potentially throwing your down and like, grabbing him? So, kind of like when she grabbed him, how would you kind of describe that?
So
Would you was it both hands and like
it was
kind of
both
like
both
and then
hands
threw him
on
to
the
the ground?
shoulders,
Shoved him to the ground.
Shoved.
It was like, did you feel it was a disciplinary thing, or it was purely
It was anger.
out of anger
It
trying
was
to kick him out?
Completely out of anger.
Okay.
It was not a disciplinary thing. There
Okay.
was no control over it.
Okay.
It was
How did he react to that?
he was crying.
Okay.
And he was upset, and he was
Okay.
crying. He's like, why, and so I picked him up, got him back on his feet, and then we started walking out, and that's when she started throwing everything out on the lawn. There's still a few things, but she cleaned
Okay.
up like most of it while I was
Okay.
sitting there by the car.
Okay. I'm gonna go talk to.
Okay.
If you want to just kind of like the other spin, fill this out. Unfortunately, I know you're probably going to be late to swim, or he's probably not going to get there at all. We do have to do our investigation, so we have to be thorough about it because
Yes.
when it is a domestic incident, we have to investigate if charges are warranted. Okay.
Okay.
So if you just want to put your name, address, date of birth, all the stuff that you do know, like report number, all that stuff, don't worry about it. If you just want to take a couple minutes to fill it out, I'll be right back with you.
Yeah, because I said you should not come back if you're not willing to do your work.
Okay, gotcha. Where are your kids at now? Were there?
I only have one child.
Okay, your child. Sorry.
He's outside,
Okay.
probably in the car. I haven't had a chance to see where he is.
Okay. Understood. So it was basically just an argument that maybe progressed a little too
I
far.
wouldn't even
and-
say it was an argument. It happened in like 10 seconds. I asked them to leave. I threw their stuff out. I tossed his music book back outside.
Okay. Understood. Alright, like I said, just give us a.
And I set my phone down, and it's in the sun, so I'd like to go get it if that's okay
We'll be
with
able to
you.
get it here in just a minute. Whenever the other officer comes in, we'll grab it. That way it's out of the sun.
Okay. This is the kind of thing that makes me think I should divorce my husband. Definitely.
Obviously,
I
I
cannot
can't-
believe he did this.
I
This
obviously
is so
can't,
unbelievably
give advice
unacceptable.
on that, but if it's leading to us being called here, I can understand, that thought process a little bit. So,
He's about to lose his job again.
understood. That can obviously make situations very difficult. I understand that.
And I told him that he needs to support himself, and he's upset. But that's not what we talked about today.
Right.
He's just in general trying to find reasons to hurt my reputation or whatever the case may be.
Has he called us before out here, on incidents, or
No,
have we never been out here before?
I called you one
Oh,
time
okay. How long ago was that?
when he was changing his medication for his depression.
Understood.
He did get violent.
Okay. Yeah, so obviously, regarding your marriage, that's something that you guys can figure out, definitely, but I would say if it's leading to, us being called here multiple times, that, never hurts to have those conversations or speak to counselors or whatever can happened. So. Obviously, just because we have to come out here for these types of calls, we do have to take a report for it. So we give everyone the option. You don't have to, but it is an option. Do you want to fill out a written statement?
No.
Okay.
I mean, should I? Should I be calling an attorney? I don't know. This is not something that I go through. I don't have any experience with this.
Yeah, so basically, obviously, what you're telling me is that there was no violence, no threats, no anything other than just, whatever happened, and you tossed their books outside, right? That's
backpack.
His backpack, okay? So obviously, that's not domestic violence. Now, if you took it and you threw it at his head, that could be a different story, but that's not what you're telling me happened here,
No.
right? So in those, obviously, that's a much different circumstance. If what you're telling me is true.
The Fourth Amendment of the United States Constitution prohibits unreasonable seizures. A custodial arrest is a seizure. A warrantless arrest requires probable cause as a constitutional minimum. Probable cause, as the Supreme Court has consistently defined it, is not proof beyond a reasonable doubt. It is not even a preponderance of evidence. It is a reasonable belief based on articulable facts known to the officer at the time that a specific person committed a specific offense. The Supreme Court's decision in Brinegar v. United States in 1949 remains the foundational statement. Probable cause exists where the facts and circumstances within the officer's knowledge, and of which they have reasonably trustworthy information, are sufficient to warrant a prudent person in believing that the suspect has committed an offense. Prudent person is the standard, not a legal scholar, not a detective, with unlimited investigative time. A prudent, reasonable officer operating in real time with the information available. Graham versus Connor, decided by the Supreme Court in 1989, establishes the reasonableness framework for all Fourth Amendment. Seizure analysis. The question is whether the officer's actions were, and objectively reasonable given the facts and circumstances confronting the officer, judged from the perspective of a reasonable officer on the scene. The Graham court specifically rejected the use of hindsight. Officers often make split-second judgments under conditions of uncertainty and time pressure. The constitutional standard accounts for that reality. Courts do not evaluate probable cause determinations against what was later learned. They evaluate them against what was known at the moment. In this encounter, the information available at the moment of the arrest decision was two independently gathered accounts from different witnesses, one adult, one child, describing the same physical act with consistent details. One denial, no physical evidence in either direction. Graham instructs that we evaluate that constellation of facts through the lens of a reasonable officer in the same position. A reasonable officer with two corroborating accounts, no physical evidence to contradict them, and a mandatory arrest statute has probable cause. Illinois versus Gates, decided in 1983, overhauled the prior two-pronged Aguilar-Spinelli test for probable cause and replaced it with the totality of the circumstances analysis that governs today. Under Gates, no single factor, the reliability of a witness, the specificity of information, the opportunity for personal observation, is independently dispositive. All relevant factors are weighed together. A weakness in one can be compensated by strength in another.
No one should probably be getting charged here today. But ultimately, he has to be able to talk to him, kind of figure out what's going on, right? But if it is nothing that no one's going to be arrested, I'm not saying that you need it to write a statement down, but it just kind of gives your opportunity to give your side of the story other than what you've already told us. Obviously, it's all documented on body camera as well. Now, if you want to get an attorney, again, this isn't anything criminal, but for like civil matter between you and your husband, that's obviously your right as well. But
I have no trust. The fact that he did this is it's absolutely absurd. I have no trust. The only paperwork I think I should fill out is maybe an ex parte so he can't come back here, because if he's willing to lie and do something like this, what else is he capable of?
And again, that would be a conversation probably for an attorney, because ultimately we can't just force him to leave.
This is wrong.
So, I mean, it's one of those things where it's like if you guys are wanting to separate and go your different ways,
This makes me want to.
I can understand that, yeah. So, like I said, we'll figure out kind of what's going on today, and then outside of that, that would be between you and your husband. We obviously don't have any control in that, so. How long have you all been married?
Since 2008.
2008. Okay. Have you always lived here, or have lived in different areas?
No, we lived in New York City
Okay.
for many years, yeah.
Wow. Didn't
We've
have
been
these.
together since I was 20 years old.
Didn't have these types of issues in the past. Is this a newer thing, or?
He has cognitive decline,
Understood. Understood. Is he
and his
diagnosed?
ADHD has gotten severely worse.
When you say cognitive decline, has he been diagnosed with
Yes.
anything? Okay. What's he diagnosed with?
Cognitive decline. It's
Okay.
like early onset dementia,
Yeah.
but it's not categorized as dementia yet
Understood.
because
It's not that
there's like
progressed that far.
stages.
Yeah, absolutely.
And he has depression
Understood.
and ADHD, and they're not sure what causes what. The neurologist isn't sure what the root cause is. That certain diseases cause symptoms, and
right.
it's kind of the chicken or the egg.
Right. It's like, understood. Understood. And how
He's not well balanced.
is he? Obviously, I know you said in the past when his medication's been off. Is that something that's been kind of stabilized for a while, or?
Yeah, when he remembers to take it, and even if he forgets, it's not the kind of medication that
Right.
like will have an immediate effect.
Right.
It's just that it's not working.
Understood.
He's just constantly forgetting things.
Understood.
It's sad, actually.
Yeah, absolutely. I mean, you spend that long with somebody, 17 years. It's a long time to.
Longer.
Yeah, I mean, obviously.
I was born in '84.
Right. So.
So,
Yeah.
yeah, much longer than that even.
Yeah.
So, it's very unfortunate.
Absolutely. So obviously, like I said, we just have to do our jobs, make sure.
But no
everything's
one
okay.
is hurt.
Yeah.
There's not been any violence.
Right. And that's what obviously we just by that, right? And then outside of that, we can, everything else will just be more of a civil matter. But if there's no violence, no threats, nothing like that, then obviously that's a much different circumstances than if there was. So that's what
Very
we just
different,
that's
yeah.
what obviously we just have to verify that and go from there. So. How long have you all lived in this house?
So we bought this house before the pandemic started.
Okay.
Shortly before.
Understood.
Yeah.
And you said it was solely over them just kind of running late today. I know it's been a repetitive behavior, but that's kind of what the tip of the iceberg was today, or that kind of forced it this obviously for us to be called out here.
Yes, I keep asking myself
Yeah.
to get up, get dressed,
Right.
be on time. You have to be punctual. You have to honor your commitments.
Understood.
If you say you're going to be in a class, you have
Be
to go
there,
to class.
right.
Doesn't matter what kind of class it is, you have to be on time.
Right.
He's just going through an extremely rebellious phase.
Right.
He doesn't want to do anything I'm asking him to do, which is very frustrating because he's a good kid,
Right. Absolutely.
but he's a dishonest child. He's not been honest about a lot of things. And I've confronted him and told him that we might have to get him like professional counseling because he's getting online more and more
Right.
and more.
Right.
Almost to the point where I am contemplating thinking maybe he has like an addiction to screen time.
Mm-hmm.
Any screen time. And it's really affecting his life in a negative way.
That's what obviously we see it a lot with kids, especially that age. It's a different culture that they're being raised in with the phones and the computers and just having that constant access.
He keeps getting into my accounts and like breaking into
Oh, wow.
my computer and my phone and like
Yeah, because I was going to say, obviously, if you have
he's
parental controls,
bypassing
but
like
he's
the
getting past that.
parental controls.
Right.
He's very bright.
That's what it sounds like.
He's
I
very,
mean,
very, very
maybe he has a
bright.
future in cybersecurity or something like that. But
he's just not respecting the rules.
right, absolutely.
And he's willing to say anything he wants to say, do anything he wants to do
Right.
to get out from underneath
Right.
school. So he's in an online school right now, and he's been in an online school, and it's been a good experience, but I've noticed this year he's having behaviors that are not what I can condone.
Right. Absolutely.
So
Understand.
it was so bad that he was in the back seat this week, and I gave him my phone to listen to some music. And when I pulled over to get something to eat, I found him on Minecraft,
Understood.
even though I told him not to. So he's just rebelling. He's
Right.
very wants to show the world that he's in control
Right.
mode.
I'm sure, I don't have kids that age, but I can imagine that I'm sure that is a tough thing to get out of them. But at the same time, I understand the importance of it. So, making sure, he
His
understands
teachers
that.
are aware. I've had conversations with his teachers about it. I've had conversations with his piano teacher about it.
Right.
And he's going to have to learn the hard way, I guess.
Has it affected his, obviously I know you said he gets behind on school a little bit, but has it affected his grades or
It
anything?
has
Have you noticed
affected
a
his
decline?
grades. Yes, it has. He's always been a straight A student, and I think he has a B,
Right.
which for is like
Right.
never happens.
Right.
It has affected his school. And it's affected his sleep, because then he has
Sure.
to stay up
Right.
and get his work done
Right.
when he should be winding down for bed or
Absolutely.
doing something else.
And I mean, obviously, there's a lot of studies that show screens and that sort of thing. If he's doing his work right before bed, you're not getting as good of sleep and that sort of
Exactly.
thing. So,
It's very important that he basically just listen to me.
I would agree with you.
It's pretty simple.
Yes.
He's just not respecting the hierarchy.
Right.
That mom is the boss and
Right. And I mean,
you aren't as the child. You have to listen to mom. You have to take a shower when I tell you to take a shower, and
right.
brush your teeth and comb your hair in the morning when you're supposed to. The normal things.
Absolutely. Sadly, it is one of those things where, obviously, I don't want to say he's taking advantage of the situation, but if there is some issues between you and your husband, your son might be picking up on that and try to, we see that a lot with kids.
And you can't spank your kids.
Right.
I mean, you can, but you can't. You can't. It's
Yep.
not.
Obviously, there's a lot of different beliefs on that.
Exactly.
But
So, I don't do that.
right, I understand.
And so, raising my voice is the extent of
Right. And it's like,
what can I do?
Right. And if you try to ground him from screens, obviously, if he still has to do his work.
That's when he
online.
really retaliates. Is
Right.
when I tell him no. When I take away the computer.
Right.
Sometimes I physically have to take it away.
Right.
He gets. It's just a bad situation with him.
Yeah.
But that didn't happen today. I just asked him
Today.
to go to swim class.
Gotcha. Does he enjoy swim? Is it something he normally?
He does. He
likes
loves
to
swim
do?
class. In fact, everything he's rebelling about, he loves doing.
Right.
He even likes school. I think he's doing it for the sake of rebellion.
Right.
Not because he doesn't like his activities. Actually, he begs to do his activities.
Doing it just to do it instead of the outcome that is happening from not being able to do it. The activities.
Yes. His violin teacher says that sometimes children like to just test their boundary in whatever way they can test the boundary or
Right.
push buttons because they want to see how far they can
Yeah.
take
That's
their
awesome.
authoritative.
Especially, I mean, you said he's 7 years old, correct? So.
He's going to be 12 in December.
Right, so obviously that's, kind of an age where boys start to feel like they're going to be men, and even though they're not there yet, that mindset starts to change a little bit. So I would say this is probably the early stages of him testing that to see if, not that he's going to be the man of the house or anything like that, but if he can, how far he can get away with certain things, so.
It's I don't know, it seems highly unusual to me.
Yeah.
I didn't know any boys like that when I was growing up that acted that way.
Yeah, I mean, obviously in my job we see this a lot, right? So I would say
You see it a lot?
yes, I would say
I would
that.
think this is so bizarre and rare and unique and
I would say this is a daily occurrence of
It shouldn't be.
these types of calls. I would agree with you. It's definitely
shouldn't be.
Yeah,
Shouldn't be a daily occurrence at all.
yeah. So
Should never happen at all.
would assume they'll be back in here in a minute. Like I said,
I don't know what they could possibly be doing.
Yeah, I would assume if your husband's just trying to share certain things, and like you said, if he is trying to talk poorly about you, I don't know if that's what's happening or not. But ultimately, there's some sort of conversation of them just trying to piece together, what exactly happened, and make sure there's nothing more than just an argument or disagreement. But
He's a good boy. My son's a good boy.
Yeah, absolutely.
He's just making a lot of mistakes.
Absolutely. Well, he'll probably do that a lot over the course of his life, but you hope
I'd
that...
rather him learn now.
Right, that you'd rather make mistakes about being on screens a little too much than something criminal or something like that, so...
Yes.
I can understand where you're coming from. It sounds like he's a pretty bright kid. If he's getting good grades,
He's
and
highly intelligent.
I mean, if he can play multiple instruments and all this other stuff, I'd say he probably is. So
I think that intelligence is part of the problem. He gets bored.
yeah, I could see that as well.
And I understand why he gets bored, but he still has to have respect for
Completely.
his teachers.
His teachers, his parents. I mean,
I tell him, like, it doesn't matter how unenthusiastic you are about whatever it is that you're studying.
absolutely.
You have to show basic respect for the people who are trying to help you learn.
Absolutely.
And the school system has required curriculum, and you have to learn it. And you have to do the tests and turn things in on time. So,
Obviously, I know you said your husband was. Is he diagnosed with anything, or is it? I know you said that you've
he
had
is
talks
not.
of professional
My
care.
husband is not diagnosed with anything.
Just take a look at something real quick.
You want to grab? Do you care if I grab her phone real quick?
yeah.
Off of,
Stay out of your phone. Where do you want me?
is it this one right here? Oh wait, it's not laying out there in the sun.
I'm just trying to figure out what happened.
Well, I already told you what happened.
Right back over there.
What is going on?
I'm not sure. They're just checking something. Like I said, if I could just have you
Are they
go over that.
videoing my whole house?
They're not taking extra video than this, and if it inside of, even if someone did request that, it's all redacted footage inside of home, so it's not something that you would have to be concerned about. So.
She need a witness statement.
She said you didn't want one, correct? The witness statement that we discussed.
Applied to eyewitness accounts in domestic violence investigations, a witness's personal interest in the outcome does not automatically disqualify their statement. It is a factor in the totality assessment, where two witnesses with potentially competing interests nonetheless provide corroborating accounts. That corroboration elevates the overall reliability of the probable cause determination. The child's account is independently significant under Gates. A minor child describing being physically thrown by a parent, interviewed separately from the adult complainant, with no obvious coordination of their accounts, provides precisely the kind of independent corroboration that strengthens probable cause beyond what either account would establish alone. Maryland versus Pringle, decided in 2003, reinforced the practical character of probable cause analysis. The court held that it is a common-sense, practical question evaluated in the context of everyday police work, not a technical legal inquiry requiring the precision of a legal brief. Pringle is particularly relevant when officers face multiple possible offenders or ambiguous factual scenarios. The court confirmed that officers do not need to eliminate every alternative explanation before concluding that probable cause exists. They need a reasonable belief, supported by articulable facts, that one particular person committed the offense. In domestic violence cases, this means officers are not required to determine the truth of the competing accounts. They are required to identify whether, taking the available evidence as a whole, there is a reasonable basis for believing a specific person committed a specific act. The subject's counter-narrative is relevant to the defense, not to the probable cause threshold.
I don't think I need to do anything.
Okay, so I have a couple other questions just based on talking to your son and your husband. I just have a couple follow-up questions, okay?
Yes.
So they again gave me a different story about how this all started. So they were saying it was potentially about a YouTube song that you saw, potentially looked up. Does that ring any bells?
No. What happened is I told him to go to swim class on time.
Okay.
And I told him he needed to take all of his things with him
Okay.
because he was going to be going with Joseph to Bologna afterwards
Okay.
and not coming back. And I said, you are late and you need to go right now.
Okay. So did you tell him to go up to his room and put his socks on? Is that... So you said he was running late, and that's what he told us to
No,
do?
I said, you need to go get in the
Okay.
car right now and have your
Okay.
shoes and your socks on. He didn't have his shoes and his
And
socks
so he
on.
said, he told us he went upstairs to get his socks on, and you followed him upstairs. Do you remember that?
I didn't follow him upstairs. He was
Okay.
upstairs coloring instead
Okay.
of getting his shoes on.
Okay. So
Yeah.
when you found him potentially coloring, not getting his socks on, what happened next?
I picked him up and I said, go downstairs right now and go get in the car because you are late.
So when you say you picked him up, what exactly did you do?
He was sitting down in his white chair and I picked him up and I put him in my arms and I started to walk him down the steps.
Okay.
Because sometimes that is the only way to get him to go. When he's
Okay.
doing his thing and he wants to keep doing it.
Okay.
So
Okay.
he is not hurt. He wasn't picked up in any kind of
Well, so
way.
and husband tell a very different story about picking him up.
I'm sure they do.
So-
They are both very much in trouble with me because they are not taking care of the responsibilities
Okay.
and being
Well,
where they need to be.
why would he lie to us?
Because he doesn't want to be in trouble.
Okay.
Again.
Okay.
For not being on time and being late and missing his
Okay.
class again.
So
For like the fourth week.
So you're saying
in a row.
nothing else happened? You just picked him up out of his chair?
I picked
put
him up. I sternly said, it's time to go and you need to go now.
Okay, so
Go get in the car.
I'm gonna tell you what they told me. Okay, so they told me that husband was going up to get his socks because he's not allowed to leave the house without socks on. So he said he was trying to get his socks on. He said you came upstairs, grabbed him by both arms, picked him up off the ground, and then threw him at that cupboard in the hallway upstairs. They said that he got off of his feet and hit his back and then fell to the ground where your husband caught him. That's what both of them are telling me.
Again.
Is there a reason why they're telling a very different story than what you're telling me?
Yes, there is.
Okay. And they also said, as you were doing this, you were telling him to, I don't want you in this house anymore, get out.
Yes, because I do. I don't want him to come back into this house this afternoon. He needs to go take
They
care
were
of his
making it seem like you meant that you don't want him in this house at all. That's how said it. He's like, he said that you have made it clear you don't want him in this house at all. He even told us a story a couple weeks ago where you dropped him off, kicked him out of the car in the middle of nowhere because you didn't want him anymore, and he had to find strangers to call someone to come and pick him up.
Okay, so as I was explaining to this officer, has been very rebellious.
Okay. 7-year-old.
It's not acceptable.
Okay.
I keep telling him he's an online student, and he's always been an online student.
Okay.
But this year school is different, and he has to do his assignments on time.
Okay.
The YouTube thing has nothing to do with today.
Okay.
The YouTube thing is an ongoing issue that I'm potentially going to hire like a psychologist or a counselor to work with him on because he's getting on screens
Okay.
repeatedly when he's
Okay.
supposed to be doing his schoolwork and he's scrolling YouTube shorts.
Okay.
And he's bypassing my parental controls on all of my electronic devices,
Okay.
including his school-issued computer, and doing that instead of doing his schoolwork.
Okay.
So I had to move my office into his schoolroom to watch him to make sure that he's not cheating, to make sure that he's staying on task, he's doing his schoolwork, and he is very, very angry because he's now not getting away with what he was getting away with before.
Okay. So I'm going to backtrack a little bit to, I want to talk a little bit more about you picking him up. Okay?
Nobody is hurt today.
It doesn't, just because no one's hurt doesn't mean something
Okay.
didn't happen.
Okay.
So
There's not any abuse that
okay,
anyone
but
did toward
did you
anyone in this
pick
house
him
today.
up and throw him at that cupboard upstairs?
No, I did not
Okay.
throw him. I picked him up and I tried to take him down the steps.
You said you tried to take him down the steps?
Yeah, I tried to walk him down the steps.
Okay, like I said, that's a very different story within what both of them are telling me.
And that is why he's in so much trouble, because he's not being forthright about his online activities. He's not being forthright about getting his schoolwork done. I caught him using Google Lens the other day trying to take a test. Google Lens is where you can like take a picture of a question and then AI gives you the answer. Well, his school doesn't allow AI. So he got grounded for that. Today I canceled his private lesson here at my house because he didn't have his theory homework done. His professor didn't come here for his composition lesson because she's been in trouble basically since he woke up this morning because he hasn't been doing his schoolwork.
Okay.
And I caught him cheating.
Okay.
This week. So, I mean, that has nothing to do with that, but I said, you cannot come back here if you're not going to follow the house rules. House rules are house rules, and they are also your school rules as well, because you do your school here in the house. And I said authorities can be called for lying and cheating and doing unauthorized activities online. He got a hold of my credit card and purchased things so he could game on the computer. So he's in trouble, and he wants out of trouble because I'm having to basically be a good mom and tell him you need to be respectful, honest, and accountable. And he's acting out.
I'm gonna go talk to him about those things that you talked to me about real quick, and then I'll be right back in, okay? Just hang tight for me for 1 second.
It would be helpful if you could tell him some of your experiences with boys that don't learn how to...
Absolutely, man.
You know.
Miranda versus Arizona, decided in 1966, addressed the coercive nature of custodial police interrogation. The court held that the inherently compelling pressures of in custody questioning undermine the privilege against self-incrimination unless the subject is first warned of their rights. The 4 Miranda warnings are constitutionally mandated: the right to silence, the right to have statements used against the subject in court, the right to an attorney, and the right to appointed counsel. A waiver of these rights must be voluntary, knowing, and intelligent. The timing question is foundational. Miranda attaches at the point of dren of custody defined by the Supreme Court in Stansbury v. California, 1994, as the point at which a reasonable person in the subject's position would not feel free to terminate the encounter and leave. The question of when custody began in this encounter is not straightforward. The subject was in her own home. She was told explicitly that no one was under arrest. She was not restrained. Under those facts, the pre-arrest interview was non-custodial, and Miranda did not attach. Oregon v. Mathiasen, decided in 1977, held that a person who comes to a police station voluntarily is told they are not under arrest and is allowed to leave, is not in custody for Dakin Miranda purposes, even if the officer already suspects them of an offense. The domestic setting in this case does not change the analysis. Being in one's own home during a police investigation does not automatically create a custodial environment. The objective test applies. Would a reasonable person in that specific situation feel free to terminate the encounter? Given that the officer explicitly told the subject she was not under arrest and the interview was conducted without restraints in her own residence, the answer under Mathiasen and its progeny is yes. She was free to leave or ask officers to leave in the pre-arrest phase. The Miranda sequence in this encounter is therefore compliant. The warning was delivered immediately upon handcuffing at the precise moment that the subject's status converted from voluntary interview participant to person in custody. No questioning occurred between the application of handcuffs and the delivery of the warning. Rhode Island versus Innis, decided in 1980, defined interrogation for Miranda purposes as express questioning or its functional equivalent, meaning any words or actions by police that they should know are reasonably likely to elicit an incriminating response. The implication for subjects is precise. Miranda does not guarantee silence. It prohibits officers from extracting statements through interrogation without proper advisement. It does not prevent subjects from volunteering statements after they have been warned. Under Innis, a subject who continues speaking voluntarily after a valid Miranda warning has been given without being questioned is generating admissible evidence against themselves. The protection is available. The subject must affirmatively invoke it. Bergwis versus Tompkins, decided in 2010, reinforced this principle. The Supreme Court held that a suspect who has received Miranda warnings and understands them must unambiguously invoke the right to silence or the right to counsel to trigger the protections those rights provide. Continuing to speak after Miranda, even at length, does not constitute a waiver by conduct that invalidates the warning, but it does generate admissible statements. The critical lesson is that invoking Miranda rights requires a clear, affirmative declaration, not silence, not ambiguity, not continued voluntary talking. The domestic violence statutory framework interacts with the Fourth Amendment in a way that creates a distinct legal architecture for these cases, one that differs materially from other categories of criminal investigation. In most criminal investigations, the arrest decision is discretionary. Officers weigh probable cause, assess the public safety interest, consider alternatives, and make a judgment. The Fourth Amendment sets the floor. Officer discretion operates above it. Ohio's mandatory arrest statute collapses that discretionary space once probable cause is established. The Fourth Amendment floor and the statutory ceiling occupy the same level. There is no gap in which officer judgment operates. The arrest is required. This architecture has a specific consequence for civil liability. Under Pearson v. Callahan, decided by the Supreme Court in 2009, qualified immunity shields officers from civil liability for conduct that does not violate clearly established law. An officer who makes a mandatory arrest in compliance with a facially valid state statute grounded in probable cause is operating within clearly established legal parameters. A Section 1983 claim against that officer faces a qualified immunity bar of substantial strength. The viable civil theory, if charges are ultimately dismissed, is malicious prosecution, which requires demonstrating that the prosecution was initiated without probable cause and with malice. Given the two-witness corroboration present here, establishing absence of probable cause would be legally difficult. The law governing parental discipline and its intersection with domestic violence statutes is among the more contested areas of Ohio criminal law. Parents have a constitutionally recognized liberty interest in the upbringing and care of their children. Troxel v. Granville, decided in 2000, confirmed that the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. Ohio courts have interpreted this liberty interest to include physical discipline within reasonable limits. The question is where those limits are. Ohio's domestic violence statute does not carve out a parental discipline exception. The absence of a statutory exception creates a gray zone between lawful parenting and criminal conduct. Ohio courts apply a reasonableness standard. Was the physical act reasonably necessary, given the circumstances, and was it proportionate to the child's conduct?
Talking to all parties. What's going to happen today is we are going to be arresting Emily for domestic violence, for her assault on your son, okay? So, she's going to be going to jail tonight. I would prefer probably not to see his mom come out in handcuffs. I feel like that's probably best for him. So, but we still have some more things we need for you to fill out. If you potentially want to maybe drive up, just like up the road just a little bit, that way it's not something that he sees. Do you have any questions about that? So the way domestic violence works in the state of Ohio, it doesn't matter whether you want to press charges. Domestic violence is if we establish enough probable cause that it has happened, we have to make that arrest. We don't have a choice. So based off of your account of what happened, I believe that is what transpired, and I do not believe she's telling me the full truth. So I do, especially for the story, and it matched up exactly with what you were telling me. So that's kind of where we're going at today, okay? Just give us a couple minutes, and she's probably going to be coming out and going back in one of our cars, okay? All right. Yep. Thank you. Yeah, and then we'll have some forms and stuff for you to fill out.
Like his cognitive decline is bad.
Okay, Emily, so I've talked to everyone involved.
Okay.
I've talked to you and your dad. So what I'm going to have you to do is, can you just turn around and face that wall for me? Can you please turn around and face that wall and place your hands behind your back? So you are being placed under arrest for domestic violence, okay?
No one is hurt.
Okay, let's just
Oh my God.
Face that way.
Did you
Hey,
hear
face
what?
that way. Spread your legs. coat.
Sorry, I wanted
It's
to
okay.
change.
You're
my
okay.
shirt. I think I have video cameras upstairs.
Okay, if you do, we'll take a look at them. But like I said, right now, based off the evidence that we have,
What evidence?
both Hudson and your husband's stories.
But that's a story, that's not evidence.
All right. So I'm gonna read you something, okay? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him or present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand your rights as I've explained to you? Having these in mind, are you willing to answer any of my questions?
The factual core of the dispute, whether the physical act was a controlled parental redirection or an uncontrolled forceful throw, is precisely the question the reasonableness standard is designed to resolve. It cannot be resolved on probable cause evidence alone. It requires a trier of fact applying the reasonable parent standard to the full evidentiary record at trial. The prosecutorial decision-making that follows this arrest will apply a different and higher standard than probable cause. Prosecutors are required to exercise independent judgment about whether the evidence supports charges beyond a reasonable doubt and whether prosecution serves the interests of justice. In cases where the only evidence is competing witness accounts, no physical injury, and a subject who provides a coherent counter-narrative, prosecutors in Ohio frequently decline to file charges or dismiss following a grand jury presentation. This does not mean the arrest was unlawful. Probable cause and proof beyond a reasonable doubt are different legal standards. An arrest can be constitutionally valid even when the subsequent prosecution is not viable. These standards operate independently and serve different functions in the criminal justice system. The mandatory arrest architecture produces what legal scholars have termed dual arrest risk, a documented phenomenon in which officers, confronted with competing accounts of mutual aggression, arrest both parties to avoid the liability that attaches to an incorrect primary aggressor determination. Most states, including Ohio, have adopted primary aggressor policies to address this. Officers are instructed to identify the party most likely to be injured in future incidents, not the party whose call came first, as the primary aggressor. But primary aggressor determinations, in ambiguous cases, remain among the most legally contested decisions in domestic violence enforcement. In this specific encounter, the primary aggressor identification was clear in the officer's view. Two witnesses described a unidirectional act. One party physically acted upon the other. There was no claim of mutual physical contact. The primary aggressor framework, as applied, produced a single arrest determination. Evidence preservation is an area where subjects of domestic violence investigations frequently fail to protect their legal interests, and where the consequences can be irreversible. The subject in this encounter mentioned home security cameras at the time of arrest. That mention was made on camera and is now part of the official record. It creates both an opportunity and an obligation for the defense. Law enforcement agencies investigating criminal matters have a duty under Brady v. Maryland, decided in 1963, to disclose exculpatory evidence to the defense. If the home security footage exists and captures the relevant incident, it falls within the Brady disclosure requirement. However, Brady applies to evidence in the government's possession. If the footage is privately held on a home system and not requested by law enforcement, it may not be in the government's possession at all, and Brady would not compel its disclosure. This creates a defense obligation. Preservation letters requesting that the investigating agency document and secure any video evidence identified at the scene should be issued through defense counsel immediately following arrest. Delay creates spoliation exposure and potentially irreversible evidentiary loss. The Fifth Amendment privilege against self-incrimination is the single most practically significant constitutional right available to a person facing investigation or arrest. It is also the most consistently misapplied, both by subjects who waive it inadvertently and by officers who test its boundaries. The Fifth Amendment, as interpreted in Miranda, protects against compelled self-incrimination in custodial settings. Its protections do not attach to voluntary statements. They cannot be invoked retroactively to suppress statements already voluntarily made. The practical implication is that the pre-arrest interview, conducted while the subject was non-custodial and cooperative, generated a record of statements that are not Miranda protected. Everything said in that interview is admissible, regardless of what happens with the post-arrest Miranda sequence. This is a structural feature of the non-custodial interview that investigators rely on. Subjects who are told they are not under arrest often speak more freely, under the belief that doing so will prevent arrest. Under the mandatory arrest framework, that belief is legally incorrect once probable cause is established. The right to counsel under the Sixth Amendment attaches at the initiation of formal criminal proceedings, not at arrest. Messiah versus United States, decided in 1964, established this principle. Pre-charge, subjects have the right to request counsel under Miranda, but not the broader Sixth Amendment. Right to counsel that prohibits deliberate elicitation in the absence of an attorney. The practical consequence is that invoking the right to an attorney during a Miranda advisement stops custodial interrogation, but it does not prevent officers from gathering evidence through other means, witness interviews, surveillance, physical evidence collection. The request for counsel protects the subject from interrogation. It does not freeze the entire investigation.
So like I said, you don't have to answer anything, but that's kind of what's happening today. So you're going to be going to jail for domestic violence tonight, okay? Mercy, if you don't mind.
You wanna go ahead and are these your shoes?
Yep, so we're going to go step this way.
Can I wear some socks? I can't go like this. I need to put an undershirt on.
It's your
You,
call.
you told me I would be able to.
We can try to grab you one, okay? We can
I haven't done anything wrong.
we can take one to the jail, or
You just have a t-shirt on underneath that? Can you just wear your t-shirt? Because they're going to give you different clothes
Yeah,
there
you're
at
not
the
gonna
jail.
I would like to have proper undergarments on.
They probably, I don't think they even let you wear those.
No, they're not gonna, yeah.
They'll give you
Can
some.
you loosen that? It hurts.
yeah, which one?
Both of them.
Okay. They're both very loose, but I can try to loosen them a little bit.
Do you wanna wear
They're
this
not meant to be
jacket?
comfortable.
Or would you rather take the jacket off and just wear the shirt? Because we can grab, I mean,
I'm not going to do anything wrong. I just asked from the very start that.
Okay, they're already really loose, so I can't loosen them anymore, okay? You have a lot of spacing here. Yeah, if you want to we're going to step this way and we're just going to face the corner of your wall. Okay. If you just want to spread your feet for me.
I thought if you would have to see some kind of hurt. Nobody was hurt.
Thank you.
A person could just make an allegation like this to get out of doing homework, and a mom can be sent to jail? You can take the coat off. I can take the coat off. I'm burning up.
Okay.
I only put it on because I wanted to be respectful
I'm
to
just
you.
gonna, okay. Do you care if she takes the
Yeah,
coat off?
I gotta take
I
these
mean,
cuffs off.
please, can I
Just do
just...
one
All
at a
right.
time.
Yep, we'll let you take the jacket off, okay?
I only was being respectful to you,
One at
sir.
a time.
Yep. Now you can just let your arm hang down the side. All right.
I'm sweaty. I was mowing the grass this morning. I was
What?
getting ready to take a
Hang on,
shower.
Turn face that way. We'll have you take them off, okay? I'll just take it off. All right, go ahead and lift your arm up side, like kind of vertical for me. There we go.
We'll take your phone with you.
It's almost dead.
Okay.
They're not gonna let you have it at the jail anyway. Go ahead and face that way again.
I'll set your jacket right over here.
Put your hands behind your back.
Yep.
please.
Interlace them like you're praying. Interlace your fingers.
Can I go brush my teeth?
Alright, go spread your feet for me. No, not right now. You don't have any
Brown
pockets
plastic
or anything
bag.
on you at all?
No,
Nothing on you.
no.
Just stick that stuff
I mean,
here
there's
if
a
she wants.
pocket above my
Yeah.
dress.
She needs
because
it.
it's a t-shirt pocket. No.
This battery, it's got 27.
Okay.
Right, we'll go back to my car.
Alright, you want to take her?
Yeah, I'll hold on to this. All right, we're gonna step outside. You wanna put your shoes on?
Yeah, go ahead and put your shoes on.
I'd rather put nicer shoes on.
Okay. Are they close
Well,
by?
they're gonna give you Crocs at the jail.
Yeah, they're gonna. Once you get to the jail, they're gonna give you a completely different set of wardrobes. So if you just want to throw those on for
Why
now,
am I going to jail?
ma'am, like I explained, you're under arrest for domestic violence. Okay, if you just want to put your shoes on.
Well, I don't understand this process. I don't understand how this could even happen. I don't understand any of it.
So we're gonna walk this way.
I'm a good person. I don't even get
I'm not-
traffic violations.
I'm not saying you're not a good person, but
This
unfortunately,
is unbelievable.
we're gonna walk to that car over there. Okay? Ma'am, when someone's arrested for domestic violence in the state of Ohio, we
I haven't offended anybody.
Yep. All right, go ahead and face the car. Just stand still. Yep. Face this way. Don't. Okay.
So if I'd called him, then he would be the one doing this?
No, ma'am. Like at the end of the course of our investigation, this is what the outcome is.
There's no investigation.
I'm gonna put the seatbelt on. Don't take it off. All right, just hang tight.
Can I get a phone number for
For her?
This hurts.
Well, I guess you can
Which
get it.
one?
You can
I mean,
get it
having
when
my
you
arms
take her.
back here like this.
Unfortunately, I can't put them in the front. They have to be in the back.
If you sit to one side, like face that window or face this window, like turn your body, don't lean on your hands, it's more comfortable. So if you like pivot yourself and face your leg one side, and face towards the window, it's not on your hands.
Where are you taking me?
Give me 1 second, ma'am. I'll explain everything to you here in a minute. All right, what's a good phone number for you? All right, just hang tight. I'll answer all your questions here in a minute.
The lead investigator conducted a methodical, procedurally sound domestic violence investigation under the constraints of a mandatory arrest statute and competing factual accounts. His overall grade is B. The investigation earns full credit on multiple dimensions. Party separation was applied correctly from first contact. Independent sequential interviews were conducted before any arrest determination was made. Miranda was delivered at the precise point of custody. The child was protected from witnessing the arrest, a trauma-informed decision consistent with Ohio's domestic violence response guidelines. The grade is reduced from an A for two analytically distinct reasons. First, a statement made to the subject early in the encounter communicated that she would likely not be charged if her account was accurate. That statement was factually contingent, accurate, given the information available at that moment, but it created a reasonable expectation that was later contradicted when the decision to arrest was made. Experienced investigators are trained to avoid communicating anticipated outcomes before an investigation is complete. The statement is not a constitutional violation and does not affect the lawfulness of the arrest, but it reflects an imprecision in expectation management that experienced officers typically avoid. Second, the on-camera probable cause reasoning did not explicitly address the credibility limitations of the two corroborating witnesses. A witness in an active divorce proceeding and a minor child facing disciplinary consequences are not disinterested parties. Their accounts may be fully accurate, but the failure to acknowledge those limitations on camera and explain why the accounts nevertheless satisfied the probable cause threshold represents a documentation gap. Probable cause documentation serves multiple functions. It creates a record for prosecutorial review. It supports the officer's immunity defense in any subsequent civil action. It demonstrates that the arrest decision was reasoned, not reflexive. The absence of on-camera acknowledgement of witness credibility limitations is a minor but genuine professional deficiency. The subject receives a grade of B+, evaluated solely on her legal conduct during the encounter, not on the underlying facts of the disputed incident. From a legal strategy standpoint, the pre-arrest interview performance was strong. The account provided was internally consistent, contextually detailed, and offered a coherent alternative narrative that a defense attorney can work with. The identification of a specific motive for witness fabrication is a recognized and effective defense strategy. The proactive mention of home surveillance cameras was a tactically intelligent move. It created an on-camera record of the evidence's existence, triggering potential preservation obligations, and establishing a foundation for a defense request for exculpatory video evidence under Brady. The grade does not reach an A for a single reason. After Miranda was administered, the subject continued speaking at length, voluntarily providing detailed statements about the child's behavioral history, the disciplinary context, and her theory of witness motive. These statements are fully admissible. The decision to continue speaking after Miranda reflects a documented cognitive pattern, the belief that further explanation will reverse a decision that is already legally complete. Under Ohio's mandatory arrest statute, once probable cause was established, no explanation provided to the arresting officers changed the outcome. The correct response at the point of handcuffing was, "I understand. I am invoking my right to remain silent, and I want an attorney." 7 words and nothing further. Every word spoken after that point became prosecutorial material. The complainant receives a grade of C+. His cooperation with the investigation was complete, and his account was detailed. These are factual observations, not endorsements, of the account's accuracy. The reduced grade reflects the legal weight of what his call set in motion, viewed against a specific factual backdrop that the legal system should scrutinize. He is a party in an active marital dissolution proceeding. He faces imminent job loss. He has documented cognitive and behavioral health conditions that affect judgment and perception. These circumstances do not establish that his account was false. They are relevant to the credibility analysis that a court will ultimately be required to perform. Under the gates, totality of the circumstances, framework, witness bias, and motive are factors in the probable cause assessment and, at a higher weight, in the trial credibility determination. The subject correctly identified the structural dynamic created by mandatory arrest statutes. The party who calls first and provides the first credible account gains a procedural advantage in the initial law enforcement response. This is legally accurate. It is not a principle of equity. It is an artifact of how mandatory arrest statutes interact with real-time, incomplete information. In a contested domestic situation with competing claims, the first credible account controls the arrest decision. The complainant was aware of this dynamic, consciously or not, when he made the call. The C+ reflects cooperative conduct in the investigation, offset by the structural legal weight of initiating a mandatory arrest process in a context where his personal interests create a material and unresolved credibility question. The department receives a grade of B-. Officers were trained, professionally deployed, and demonstrated awareness of child trauma considerations in their execution of the arrest. The grade reflects a structural limitation that is not specific to this department's conduct, but is inherent in how mandatory arrest statutes operate in cases at the margins of the probable cause threshold. When no physical injury is present, when accounts are directly conflicting, and when the corroborating witnesses have identifiable personal interests in the outcome, mandatory arrest legislation requires officers to resolve a factual ambiguity at the arrest stage, a function that the legal system otherwise assigns to prosecutors, grand juries, and trial courts. The documented research on mandatory arrest policies, including studies by Lawrence Sherman and colleagues published in the 1980s and 90s, consistently identifies this as the primary structural cost of mandatory enforcement, the elevated risk of arresting a person who committed no crime in the class of cases, where probable cause and factual accuracy diverge. The B- grade recognizes professional execution of a demanding legal framework, while acknowledging that the framework itself, in cases like this one, produces outcomes that reasonable, fully informed decision-makers with unconstrained discretion might not choose. Technical compliance with a statute and optimal policy design are not the same metric. The lessons from this encounter are addressed to 4 distinct audiences: subjects of domestic violence investigations, persons who initiate domestic violence calls, law enforcement officers, and policy observers. Each lesson is derived directly from the legal analysis applied to this footage. For subjects, Ohio's mandatory arrest statute means that once an officer determines probable cause exists for domestic violence, the arrest cannot be prevented by explanation, cooperation, or denial, no matter how credible or detailed. The correct legal response at the moment of handcuffing is an unambiguous invocation of the right to silence and the right to counsel. Every statement made after that point, whether answering questions or speaking, voluntarily creates an admissible record. The courtroom, not the kitchen, is the correct venue for explaining what happened. For subjects, home surveillance evidence, if it exists, must be preserved immediately. Once an arrest is made, the burden shifts to the defense to gather and present exculpatory evidence. Preservation requests through defense counsel should be transmitted to the investigating agency in writing within 24 hours of arrest. Digital footage overwrites on a cycle. Delay is evidence destruction. For complainants, initiating a 911 call in a mandatory arrest jurisdiction is not the same as reporting a crime in a discretionary enforcement context. In Ohio, a call that produces probable cause produces an arrest. The investigating officer does not have the option to mediate, separate the parties, and leave. This consequence should be understood before the call is made. For complainants, the credibility analysis does not end at arrest. Witness accounts are subject to rigorous scrutiny at every subsequent stage: prosecutorial review, preliminary hearing, grand jury presentation, and trial. A witness whose account was the engine of a mandatory arrest will be cross-examined on every aspect of that account, including motive, perception, and relationship dynamics. For officers, the on-camera probable cause articulation is not a bureaucratic exercise. It is legal documentation, an explicit on-camera statement identifying the specific articulable facts, supporting probable cause, and acknowledging known credibility limitations while explaining why those limitations do not defeat the probable cause determination. Builds a record that protects the officer, the department, and any subsequent prosecution. For officers, communicating anticipated outcomes before an investigation is complete, creates legal and interpersonal risk. The conditional statement, if your account is accurate, no one will be charged, is factually contingent. When subsequent evidence changes the calculus, the subject experiences the inconsistency as a breach of trust. Experienced investigators frame such statements in terms of the investigative process rather than the likely outcome. For policy observers, mandatory arrest statutes produce a predictable category of problematic outcomes cases where the probable cause threshold is satisfied, but factual accuracy is genuinely uncertain. In those cases, the mandatory framework places the consequences of investigative uncertainty on the subject rather than deferring to prosecutorial review, where the standard is higher and the information is more complete. This is a legislative choice, not a law enforcement failure. Departments cannot improve their way out of structural statutory limitations. The appropriate venue for addressing mandatory arrest policy is the legislature, not the police review board. The arrest captured in this footage was lawful. Two independently gathered, corroborating accounts describing a specific physical act by a specific person satisfied the Fourth Amendment probable cause standard. Ohio's mandatory arrest statute then required the arrest that followed. Lawful does not answer every question the footage raises. It does not resolve whether the act occurred as described. It does not evaluate the fairness of a legal framework that compresses the fact-finding function to the probable cause level in cases where the evidence is genuinely ambiguous. Those questions belong to the court system, to the prosecutor, who will decide whether to file charges, to the judge, who will assess whether probable cause supports detention, and ultimately to the fact-finder, who will determine, on a standard of proof, beyond a reasonable doubt, whether the offense occurred. What this footage establishes is the architecture of a mandatory arrest system operating as designed. The officers applied the law correctly. The statute operated as the legislature intended, and a person sits in the back of a patrol vehicle who may or may not have committed the offense for which she was arrested. That unresolved uncertainty is not a failure of this encounter. It is the design feature and the design cost of every mandatory arrest statute in operation. The 14th Amendment's Due Process Clause provides an independent, constitutional basis for evaluating domestic violence arrests. Procedural due process requires that a deprivation of liberty and a custodial arrest is precisely that follow fair procedures. The Supreme Court addressed the intersection of due process and domestic violence enforcement in Town of Castle Rock v. Gonzalez, decided in 2005. The court held that mandatory enforcement statutes do not create an entitlement to police enforcement that rises to a protected property interest under the 14th Amendment. Castle Rock's doctrinal significance for this analysis runs in reverse. While it holds that victims cannot sue for failure to enforce, it confirms the structural reality that mandatory arrest statutes are policy instruments backed by constitutional validity, not individual rights provisions creating enforceable claims. The evidentiary framework applicable at any subsequent trial operates under an entirely different constitutional architecture than the probable cause analysis governing the arrest. This distinction is often misunderstood. At trial, the prosecution must establish every element of the offense beyond a reasonable doubt, the standard articulated in re Winship, decided by the Supreme Court in 1970. The reasonable doubt standard is the highest evidentiary threshold in the American legal system. It exists specifically to protect defendants against wrongful conviction in cases of evidentiary ambiguity. The gap between probable cause, a reasonable belief, and proof beyond a reasonable doubt, the elimination of reasonable doubt, is enormous. Cases that clear the probable cause bar frequently fail to reach the beyond a reasonable doubt threshold. This is not a flaw in the system. It is the system performing its designed function, filtering potentially erroneous arrests through progressively higher evidentiary standards. In domestic violence cases with no physical evidence and competing witness accounts, prosecutors frequently decline to file charges following arrest. This is consistent with the due process framework. The mandatory arrest statute handles the initial deprivation of liberty, and the prosecutorial review stage applies the higher standard before formal charges are filed. The Confrontation Clause of the Sixth Amendment guarantees a defendant the right to confront witnesses against them. Crawford v. Washington, decided in 2004, fundamentally restructured how courts evaluate out-of-court statements in criminal trials. Under Crawford, testimonial statements made to law enforcement, including statements given during a domestic violence investigation, are subject to the Confrontation Clause. They cannot be introduced at trial unless the declarant is available for cross-examination, or the defendant had a prior opportunity to cross-examine them. This has specific implications for domestic violence prosecutions in which the complaining witness recants or becomes unavailable. Davis v. Washington, decided in 2006, drew the line between testimonial statements made when the primary purpose is to establish past facts for potential prosecution, and non-testimonial statements made to respond to an ongoing emergency. The practical consequence: statements made to officers during the crop 16 initial emergency response phase before the scene is secured, and the investigation shifts from emergency response to evidence gathering, may be non-testimonial and therefore not subject to the Confrontation Clause. Statements made during the formal interview phase of an investigation after the emergency has passed and officers are gathering evidence for potential prosecution are more likely to be testimonial and subject to Crawford's Confrontation Clause requirements. In this encounter, the extended interviews occurred after the scene was secured, and parties were separated squarely in the testimonial phase of the investigation. Any statements introduced at trial from those interviews would require the declarant's presence for cross-examination under Crawford. Hearsay and its exceptions represent another significant evidentiary dimension in domestic violence cases. The federal rules of evidence and Ohio's analogous rules generally prohibit out-of-court statements offered for the truth of the matter asserted. The excited utterance exception, codified in Federal Rule of Evidence 803, subsection 2, permits admission of a statement relating to a startling event made while the declarant was under the stress of excitement caused by that event. In domestic violence cases, excited utterances made immediately following an alleged assault are among the most significant pieces of evidence precisely because they precede the opportunity for reflection, coaching, or recantation. Investigators trained in domestic violence response are taught to document contemporaneous statements made by victims and witnesses at the earliest opportunity for exactly this reason. In this encounter, the investigation began approximately at the time the incident occurred based on the Bodycam timestamp and the subject's account of events occurring immediately before officers arrived. Statements made by the child during initial contact would qualify for excited utterance analysis if the emotional state is documented. The Fourth Amendment's exclusionary rule, established in Mapp v. Ohio, decided in 1961, provides that evidence obtained through unconstitutional searches or seizures is inadmissible in criminal proceedings. Ohio was specifically the case that incorporated the exclusionary rule against state actors. The exclusionary rule has limited direct application in this encounter because no search of the premises was conducted and no physical evidence was seized. The sole evidentiary products of this investigation are witness statements and body cam footage, neither of which requires a Fourth Amendment predicate. If, however, the investigation had proceeded to a search of the premises, including the security camera footage mentioned by the subject, officers would have required either consent, a search warrant, or a recognized warrant exception such as exigent circumstances or plain view. The mention of the cameras on Bodycam creates a documented basis for a defense preservation request but does not automatically authorize law enforcement access. The Double Jeopardy Clause of the Fifth Amendment prohibits a person from being tried twice for the same offense following acquittal or conviction. While this principle has no direct application at the arrest stage, it becomes critical if charges are filed and the case proceeds to trial. In domestic violence cases involving a parent-child relationship, the charging jurisdiction may overlap with child services investigations conducted by civil authorities. Civil child abuse findings and criminal domestic violence prosecutions can proceed simultaneously, without implicating double jeopardy because civil protective proceedings and criminal prosecutions are distinct proceedings, serving distinct purposes. The Blockberger test, established in Blockberger v. United States in 1932, determines whether two charges constitute the same offense for double jeopardy purposes. Each charge must require proof of an element that the other does not. Domestic violence and child abuse charges arising from the same conduct typically satisfy the Blockberger test, meaning both can be prosecuted without double jeopardy violation. The bail and pretrial detention framework following a domestic violence arrest in Ohio is governed by Ohio Revised Code Section 2919.251. This provision creates a mandatory hold period before arraignment for persons arrested on domestic violence charges. The hold period exists to prevent the arrested party from returning to the residence and potentially intimidating witnesses or escalating the situation before a court can conduct a meaningful dangerousness and flight risk assessment. Ohio courts have upheld this provision against due process challenges on the grounds that the government's interest in preventing recidivism and witness intimidation justifies the brief pre-arraignment hold. At arraignment, the court will conduct a bail determination under the standards established in Stack v. Boyle, decided in 1951. The Eighth Amendment prohibits excessive bail. In domestic violence cases, courts frequently impose no-contact orders as a condition of pretrial release, meaning the arrested party cannot return to the shared residence or contact the alleged victim pending trial. No-contact orders have significant practical consequences in cases involving cohabitants, particularly when minor children are involved. An order preventing a parent from contact with their child pending trial is a severe civil consequence that flows directly from a domestic violence arrest, irrespective of whether charges are ultimately sustained. The collateral consequences of a domestic violence arrest, distinct from any criminal conviction, are among the most severe of any misdemeanor-level charge in the American legal system. This is a systemic feature that the legal analysis must address to be complete. Under the federal Lautenberg Amendment, codified as 18, United States Code Section 922, subsection G, subsection 9, a conviction for a misdemeanor crime of domestic violence permanently disqualifies a person from possessing any firearm or ammunition. This applies to law enforcement officers, military personnel, and civilians alike. A felony domestic violence conviction triggers even broader consequences: loss of voting rights during incarceration in Ohio, potential immigration consequences for non-citizens under 8 United States Code Section 1127, and mandatory sex offender registration in cases involving certain offenses against minors. These collateral consequences operate independently of and in addition to any criminal sentence. They are not imposed by courts as discretionary sanctions. They are automatic statutory consequences that attach upon conviction regardless of the sentence imposed. The severity of these collateral consequences is why defense counsel in domestic violence cases frequently pursue diversion, deferred prosecution, or dismissal outcomes aggressively, even in cases where the underlying conduct might otherwise support a plea to a reduced charge. The downstream stakes of a conviction, however minor the underlying conduct, are disproportionately high. This encounter, viewed in its totality, illustrates the legal architecture of domestic violence enforcement in a mandatory arrest state, from the constitutional foundation in the Fourth Amendment through the statutory framework of Ohio Revised Code to the evidentiary rules governing any subsequent prosecution. Each layer of that architecture reflects a distinct policy choice made by a different branch of government. Constitutional limits, set by the Supreme Court, statutory framework set by state legislatures, evidence rules set by rulemaking bodies, and enforcement discretion, what remains of it, set by officers, applying all of the above in real time. Understanding that architecture does not resolve the factual dispute at the center of this case. It does not tell us what happened in that upstairs hallway. What it tells us is what legal consequences attach to competing versions of what happened, and what procedural machinery has been set in motion to resolve the dispute. The resolution of that dispute will occur, if it occurs at all, in a courtroom under a standard of proof higher than the one that governed the arrest before a fact finder with access to evidence that may not be available today, and applying procedural rules designed for precisely this kind of contested credibility question. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, And don't forget to subscribe to our channel for more content on police court interactions.